frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
Woo! Guys, I got a fire one for you today. This repeat offender walks back into court thinking it's just another hearing. But this judge has seen it all before and is not holding back. Tensions explode as the judge calls him out, and everything unravels fast. You won't believe how hard this gets shut down. For non-stop courtroom drama and daily uploads, subscribe to Daily Courtroom Drama. Now let's jump into it.
Thank you.
Chris Clare on behalf of probation. Your Honor, Mr. Carter is before the court for an adjourned violation of probation. Mr. Carter, when he was last before the court, did have a pending felony case. The court did arraign him on that bench warrant. He was set for court. That case that is pending is now set for appeal on November 5th. Mr. Carter now has another new pending case, domestic violence second offense, and it interfered with communications with an alleged date of offense of October 20th, 2024. He is on bench warrant status in that case. Given that there has been continued alleged assaultive behavior with the added victim in this case, because the court did add a no contact with that victim, it does make it a violation of this case. Probation's asking that the court, one, address the felony warrant on that 2-4-FB case, if the court does have it, that the court revoke probation and sentence Mr. Carter to jail 365 days, credit for 162 days served to serve the balance, that he complete the jail DV program, waive remaining terms, accepting his financial obligations, and discharge him from probation without improvement.
Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. We're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning and this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaint.
Well, while that's good, he got a new job. Don't do stupid stuff that gets you arrested and makes you lose that. It's called responsibility.
Witness in both these cases is the same person who has actually reached out to me before, Your Honors, indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's on tether. What's it? He's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October the 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So 2 weeks later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they had contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the scope of probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. That the defendant will submit to random drug test when requested. He's not to leave the state of Michigan without permission of the court. You're not to possess, purchase any firearm, ammunition, or other dangerous weapon. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are to have no contact with Jennifer Matlock except by a civil standby with the police. You cannot have any direct or indirect contact with the above named person, Miss Matlock, in person or through others or by electronic communication, including but not limited to phone, email, texting, internet, social media, or refer to the person listed online in any form whatsoever. You are not to go to I have a location at 1265 Russell Street.
I'll check that, Your Honor, while you continue and double check that that's correct.
You are not to go to that location except with civil standby with the police. If this is your home address, you must find another place to live and notify the court of your new address within 24 hours of any release from incarceration. You are not to violate any criminal law. You're to personally appear at all court hearings and other places as directed by the court. You understand all of those conditions?
Yes, sir.
And Your Honor, that address is the location where the incident took place. Did we also ask the defendant be prohibited from going to a Glencoe Hills address? I can give the court whenever it's ready.
Yes, go ahead.
22, well, actually, we can request the Glencoe Hills apartment complex in general, specifically 2252 Glencoe Hills Drive in Ypsilanti.
225.
2.
Better, I'm not entirely sure what is going on with you in that regard.
Not litigated.
Don't be a repeat offender. Don't commit crimes. Unless you're willing to do the time. And then I still don't recommend it. Don't do it.
I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk, but you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to
Go
interrupt.
ahead.
Sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So. But I wouldn't, but
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in, even after that, let you go.
Simpson, I said something.
You can say whatever you want.
I understand. Just, she put up on me. I was in the room playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car and that's when I pulled off.
Well, maybe that's all gonna come out, Mr.
I understand.
Carter. Maybe that's all gonna come out. I let you out the last time. Should have of all rights locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? I end up, you get that other case set for exam. Then what ends up happening? I get here and you got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is.
I
You have got all of these charges.
understand. I take
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I post sentence on that case?
Want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself.
Bro, come on now. Just own up to it. Can't make a terrible choice and then blame other people for your consequences. Come on now. Judge Simpson's hopefully going to nail him pretty hard for this.
So, I mean, I understand. You understand it. When I get out this situation this time, I'm be by myself. I just know.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served, defendant is to serve the balance.
Your Honor, the court ordered the Dawn Farm program. Probation also requested the DV program. I just think they just requested DV. The court want the defendant to perform both or just one or the other.
I should have said in jail DV program
Thank you.
is what I meant to say.
Thank you.
Thank you.
Oh boy, he wasn't giving him another chance to go free. Not with the possibility of felonies on the line, and it sounds like potentially domestic violence. So I completely agree. Keep the guy locked up. Suck if it turns out that it was all made up or exactly as he described, but you know what? We gotta take the can't take the chance anymore. Sorry, bud. If you want to see more drama like this, make sure to like and subscribe to Daily Courtroom Drama, where we upload twice a day, and I'll see you on the next one.